good afternoon. My name is Matthew Talbot, and I'm an elder law attorney in Contra Costa County, and I do a lot of elder abuse work within that umbrella. And I wanted to talk today about one aspect of elder abuse, which is undue influence. So California Probate Code 86 defines undue influence by looking at Welfare Institutions Code 15610.70. I know there's a lot of numbers here, and it can be confusing, but if you look at that Welfare Institutions Code, it gives a general definition of elder abuse with 4 key factors that further define it. So the general definition is sort of excessive pressure that somebody puts on another person to get them to either take an action or not take an action. And it might be something like, if you don't sign this document giving me all of your assets when you die, I'm going to withhold your medication. If you truly loved me, you would sign this deed transferring the property to me. So that, that has to be done excessively, that pressure, to get the person to either take an action or not take an action. Of course, with not taking action, that would be the alleged victim saying, I'm thinking of signing this document that gives everything to your brother, what do you think? And the other child saying, don't do that, and then applying the excessive pressure. So what are the 4 factors here? These further define the court's look and focus at undue influence and help guide attorneys in providing sort of a shepherd for their clients through this process. The first is vulnerability. How vulnerable was the alleged victim? And this just isn't mental incapacity. It could be education. It could be physical incapacity. They have to kind of look at a lot of different factors. But of course, if they suffer from dementia, that is one of the most common factors that would lead to vulnerability in an alleged victim. The second is apparent authority, and this is, I think, the most confusing factor. What is apparent authority? That is someone who could take advantage of a vulnerable person. Maybe a family member, maybe a caregiver, maybe a professional fiduciary, someone who is in a position to take advantage. So what is the likelihood that that person could take advantage? That's the apparent authority. The third factor is actual actions taken. So is there evidence that the alleged abuser kind of stood over the alleged victim and said, you need to sign this document right now? Those are actual actions taken. Actually withheld medication until they signed the document. Things along those lines. That can be hard to prove because it usually happens behind closed doors. So the courts have a rule that circumstantial evidence can be sufficient in that instance. So the evidentiary barriers are lessened for that particular factor. And the last factor, which is an important factor, of course, is the what's called the inequity, or essentially unfairness of the result. So if there was 4 kids and mom does a trust giving everything to one of the kids, and there's no other reason to do this, that seems unfair. Of course, if one of the kids stayed home with mom and took care of mom, the other 3 kids left and never talked to mom for 20 years, then there would be more of a fair result. So you have to look, it's not done in a vacuum, as the specific case says. You have to look at the evidence as to the fairness of it. And cutting out people in and of itself is not evidence of inequity. And the code section actually says that. You need more than just evidence of inequity. So those are the 4 factors that are analyzed when looking at undue influence. And if you are concerned and you think that maybe someone is under the undue influence of somebody else, you should contact an attorney and talk with them to ensure that everyone's rights are fully protected during the lifetime of the alleged victim, hopefully, and if not, then afterwards. Thank you so much.